Welcome back. As you know, my name is Brian Burkhoff, and this is the New Jersey Workers' Compensation Conversation. Today we'll be talking about the third benefit in New Jersey cases, permanency benefits. What is a permanency benefit? When you hear this term, I want you to think about functional loss. A functional loss occurs when somebody was previously able to do an activity that they're no longer able to do. So we're going to give an example to illustrate this point. Let's say that there's a nurse who was attacked while working in the hospital. After the attack, she went to the emergency room and it was discovered that she had a full tear of her rotator cuff. This required invasive surgery, months of post-operative physical therapy, but ultimately she was able to return to the same job full duty, and she noted that she felt 100% back to normal with no additional issues. Is this nurse entitled to permanency benefits? There's a two-step test to decide if she is, and we're going to discuss that now. A petitioner is only entitled to these benefits if they can prove a functional loss as per the tests that are outlined in the Perez case and Section 36 of the statute. First, the claimant must show objective medical evidence of a restriction of their bodily function, and secondarily, they must show that this resulted in a lessening to a material degree of their ability to work or a substantial impact on their activities of daily living. So, let's apply the test in the case of the nurse. Does she have objective proof of a restriction of the body? The answer to that is clearly yes. She has an MRI showing a full tear of her rotator cuff in her shoulder. But is she able to satisfy the second prong of the test? Well, she doesn't have any restriction of her ability to work because she was able to return full duty to the same job. She also notes that she's 100% back to normal, so there is no impact on her activities of daily living. So in this particular case, petitioner should not be entitled to any permanency benefits. But let's change these facts. Rather than returning to the same job at full duty, petitioner returns to work for the same employer but has to work at a sedentary position. At home, she can no longer do grocery shopping or lift laundry to the second story of her home. She also cannot care for her grandchild, who she used to babysit 3 days a week. And she has various other restrictions in terms of her ability to maintain the house, such as vacuuming and lawn care. So given these facts, would the petitioner now be entitled to permanency benefits? The answer is yes. For the second step of our test, she has now been able to prove that she had an impact on her ability to work because she is now at a sitting position all day. And secondarily, she has had a substantial impact to her activities of daily living based on the residual impacts of this work accident. So now that we know how an individual becomes entitled to these permanency benefits, we have to discuss how we determine what they are worth. This is the judge's job in all the cases that we deal with. But ask yourself, what would these disabilities mean to you? If the shoulder was previously at 100% and now the nurse cannot do these various things at work and at home, should the shoulder be deemed to be 10% less, 20% less, 30% less? We have to figure out what percentage her shoulder has dropped to compared to what it was previously. Let's say that we agreed to an award of 25% of partial total. That would mean that the ability for her to use her shoulder has dropped from 100% down to 75%. Now I want to move on to a different aspect of determining what we pay in permanency awards. Let's say the same nurse who was going to receive an award of 25% is discovered to have had a prior workers' compensation accident where she received an award of 15% for a partial tear of the rotator cuff specifically. In this scenario, the partial tear has worsened to a material degree and become a full tear which required the surgery, so we would still have to pay a permanency award. However, we would get what's called a credit for the 15% that she was already awarded, which would reduce the amount that we're pay. We're not going to pay more than the 25% that we previously agreed to, although petitioner's attorneys often argue the overall value of cases are increased when a credit is added. This is an incorrect practice, as we argue that disability is disability. Petitioner's restrictions of work and her daily living have not changed, and therefore the value of the claim do not go up simply because we have discovered this prior accident. So, this prior 15% credit sounds great, but what does it actually entail in terms of dollar figures for our case? If we were just to have paid the award of 25% of the shoulder, it would have been about $50,000 for the award. However, now paying 25 with a 15% credit is only $23,000. So we're saving about $27,000 by having discovered this credit through our own investigation. It's why it's very important to look to see if an individual has ever had a prior injury or a prior award to a body part that's involved in your claim. However, prior workers' compensation claims are not the only way that you can receive credits or be able to lesser the value of the claim that you're dealing with. We also want to look for ISO reports to see if there's any indication of prior accidents, such as motor vehicle claims. We want to look to get petitioners' primary care records if we have an indication that they previously treated for the body parts at issue. We want to look to see if there's a potential third-party case in an example such as a delivery driver gets rear-ended, and not only will they file a workers' compensation claim, they'll be able to file a civil lawsuit against the driver that hit them. We would be entitled to a credit on some of the payments we have made by a lien against the third-party case. And finally, we want to look to see if there's been any subsequent accidents that may be able to cut off causation and greatly reduce the value of our claims. Moving on to our next video, we'll be discussing permanency benefits and specifically how the awards are paid. As you now know what they are and how to calculate what they should be paid at in terms of percentages, we'll go through the specifics of the dollar figures and how the petitioners are receiving those checks. If you have any questions about the topics that were discussed today, feel free to reach out to me via email or phone, and I'll be happy to answer any questions you might have. I'll answer your questions privately or on one of our upcoming videos. And with that, I thank you for listening, and I hope you have enjoyed our compensation conversation.